Good morning. Happy Saturday. I feel somewhat silly. I watched the video of Otto, or that Eric made about the judge getting butt hurt in Otto's case. And somehow audio didn't play. So I didn't realize that there was audio on it. So I'm dumb. Anyway, having listened to the audio, yes, everything I said is magically manifested as true. The judge was not butthurt. Otto didn't want to do paperwork. Otto made lame excuses. They won't tell me what paperwork they need. The judge was very patient in explaining that you have to fill out the paperwork. There's nothing he could do for you until the paperwork's filled out. It's got to be properly in front of him. The judge can't just say, apparently, that you don't have the funds to be able to afford an attorney. He has to have something in front of him showing that you don't have the funds to afford an attorney. In family law, as a first-year family law attorney, every time I go in for a fee waiver or child support or spousal support or attorney's fees, very first thing I do is I fill out an income and expense declaration that shows how much money you have, how much money you make, and how much money you spend, and how much in debt you are. Every time. It also shows how much you've paid your attorney and how much you still owe your attorney, which are two very important categories to me. They're near and dear to me. And that way, the judge has information in front of him at the time he's making his decision as to what the ability of each party is to pay and what the need of each party is for money. I have never been a public defender. I don't deal with indigent criminal defendants, so I'm not, and I'm certainly not an attorney in Colorado, so I have no idea how it works for fee waivers or for public defender assistance, but I'm sure that the judge would still require some evidence in front of him, even if it is only declarations showing that there is an actual need. Because remember, they don't have to appoint a public defender, at least under the Constitution of the United States, which sets the floor. They don't have to appoint a public defender unless the person can't afford an attorney. So the metric is, can you afford an attorney? Otto has to show that he cannot afford an attorney. Now, Otto was very butthurt that this judge patiently explained to him that there's nothing the judge can do for him until Otto fills out that paperwork. The judge understands what Otto wants. Otto wants to skip to the head of the line and get his public defender and never have to fill out a scrap of paperwork. Otto doesn't seem to be he doesn't strike me as the kind of guy who's very good with paperwork. But the judge isn't going to do that. The judge probably can't do that. Just saying. And the judge certainly won't do that, especially if you're being a dick to him. Now, Otto threw a hissy fit. He flipped the judge off on the way out of the courtroom. Well, first he tried to walk in the well. The well is that area in front of the counsel table, between the counsel table and the judge's bench. You're not supposed to approach the judge. You're just not supposed, unless the judge invites you up, you're not supposed to approach the judge. It's a courtroom security thing, it's a respect thing, it's a decorum thing. I don't do it. I mean, you're not supposed to approach the clerk. I mean, sometimes attorneys will do it, especially if they know the clerk and the bailiff's okay with it and the court's okay with it. And some courts are and some courts aren't. But anyway, that well area, you don't go in it. You're just not supposed to. And the judge patiently explained, you just don't do it. I'm not mad. It's okay. Just letting you know, don't do it. If you do it again, you'll get a different result. That was a breach of court etiquette. That was a breach of court decorum. That was a showing of disrespect to the court, not the judge, the court. And then Otto flipped off the court. The judge is the court. When he's sitting up there, he is the court. And the judge very patiently again explained it. Look, you could hate me, you could loathe me, you could disdain me, you could be defiant. You can think I'm the dumbest guy in the world. You can hate my guts. But you don't flip me off. You gotta show decorum, you gotta show respect in the courtroom. And attorneys don't do it. And you know why attorneys don't do it? Attorneys don't do it because, number one, they're gonna have to be in front of that judge again. And number two, they know that they can get smacked with contempt. We're not dumb. Which leads me to a joke. What do you call an attorney with an 80 IQ? You call him Your Honor. Eric the Fatid was wondering, he was just concerned about me, don't you know? He's wondering what would happen if the judges heard that I disparaged them. Well, why don't you take that clip, that sound recording that I just made of me calling judges 80 IQ lawyers, go and play it for them. They won't care. I wonder when people are going to get tired of trying to threaten me. It doesn't ever seem to work. And anyway, so yeah, the court did not seem butthurt. The court seemed very patient up until he dropped that 30-day contempt. That was a bomb right there. I mean, that sends a message. That will certainly be something that Otto will remember. Rightfully so, I should say. So then there's another issue that came up. Apparently, Earl's pretending to been gonna file a lawsuit. I love all these guys who are been gonna file a lawsuit, and they're been gonna post up all the documents after they file the lawsuit. I mean, this is obviously something that we have seen time and again. Methy Mouse has done it, D-Cup's done it, Patty Cakes has done it, Earl's done it. I mean, I think, did Ben threaten? I know Ben threatened me with a lawsuit, but I don't think he actually said that he was gonna file it or anything, or post up the. Anyway, my point is that it's 99% probably a lie. Now, what would Earl have to show with this lawsuit? Well, YouTube took his videos down. Well, him and his sons, obviously. Him and his son's videos down. And they did it because of privacy complaints. Earl saying it's from a deputy and from a person who works for an independent contractor, who were both featured in the videos. Now, just from like a constitutional law, First Amendment point of view, Google has the right to control the content in their platform. Google is not the government. First Amendment, unfortunately, does not apply. I mean, if Earl really wants to, I would donate. If Earl really wanted to start some sort of a lawsuit to turn Google into an actual free speech platform that's covered by the protections of the First and 14th Amendment, then yeah, I'll donate. There's actually an attorney, Lear Lesser, who I've donated to. He has a YouTube channel, like YouTuber Law or something like that, where he's working on that very subject. I haven't checked in with him for a long time. I don't even know where he's at on it. Anyway, but that's obviously not what he's doing. He wants to sue the sheriff's department, and I'm assuming the independent contractor. Well, the problem is, again, it's YouTube who took the action. Two private individuals submitted complaints. What the deputy does in his personal time is his time, and he could submit privacy complaints. Just because he's a deputy, despite popular opinion, doesn't strip him of his rights or of his privileges to submit claims to YouTube. He can still do that. So the question becomes, is the government acting? If he's actually going for a First Amendment violation, is the government acting? And that's going to be a hell of a causal chain. He's going to have to show that the deputy is acting in his professional capacity. I think the independent contractor deal, that's not going to happen. Independent contractors are private citizens. Oh, I have a contract to clean government outhouses. I pump the poop out of government porta potties. Oh, you're a government contractor. You are, you can't tell me to shut up now or you'll violate my First Amendment rights. It's stupid. There's actually tests for that. But essentially speaking, if the government has hired somebody to regulate or police something like a private security company, then it's the government acting, generally speaking. It has to be the government acting. It can't be someone acting who is also incidentally receiving money from a contract from the government. So he's gonna have to prove that the sheriff was acting as the government, the deputy, was acting as the government, and that the deputy somehow forced Google to censor Earl. And Earl says he's got an attorney. Every time Earl's lips move, I just assume he's lying. It would be an interesting case. If someone came to me with that case, I would take it on an hourly basis, because right out of the gate, if it's state law, it's going to be a demur or a motion to dismiss of some sort. If it's federal, it's going to be a 12B6 motion that you're going to have to survive. So you're looking at a lot of work right up front, and proving damages. If you're actually going for damages and not injunctive relief, I'm assuming Earl's going for damages because that's how these guys all think. They think in terms of dollars and cents. So damages are going to be essentially nil, because you've got to remember Earl's YouTube account was demonetized, and his son's YouTube account is his son's. So Earl has no damages. 0 damages. So yeah, I'd take it on an hourly, because there would just be a ton of work, and you got a long road to hoe to prove that whole chain. But I mean, it would be an interesting lawsuit to work on. Unfortunately, Earl is spending all of his money on his legal defense for the criminal trial, and he's probably not going to be funding any lawsuits anytime soon. Anyway, thanks for watching. Have a great weekend.